Hey there, my name is Taffy Rice, and the video you're about to see is a December 9th Patriot meeting in which I was a guest speaker. It was an honor to be among Georgians who recognized the loss of liberties and the property war currently going on in both our state and country. My husband and I, after having been engaged by a powerful law firm, Brock Clay Calhoun, were forced to represent our own interests in court. And it is as a result that we learned in protecting our children and our property some of the ties and the efforts going on that most Georgians have only now begun to understand. We discussed CAI, Community Association Institute, a powerful lawyer pack that is trying to control the courts and property rights of every American today. We also discussed the condition of our judiciary based upon an oral argument my family presented to the Georgia Supreme Court on November 7th, also available on YouTube. In the matter before the Georgia Supreme Court was the issue of a writ of prohibition against Judge Adele Grubbs, a powerful judge, honorary member of the Defense Department, but one who chose to act outside her judicial canons and Georgia law. From that effort, what you will learn about is one couple's stance on fighting wrong and standing up for what is right and the fundamentals of America. I hope you'll take the time to view the video in its entirety and to also rate it if you don't mind. Our quest has included not only lectures, articles, and speaking engagements both on radio and in person, but in addition, my husband and I ran for political office, the first couple in the history of the United States to run in tandem. This story was barely covered by the media, and they refused to print our stances on case precedent and judicial immunity. As you begin to learn a little bit more of the nature of these particular principles and how they deny American liberties, I hope you too will understand the depth and the gravity of these powerful issues affecting every American's daily life and property. For more information on both the situation that brought our quest to light, please feel free to visit www.ricegang.com. You'll find scanned documents, pictures, and additional information. For other articles and property stories affecting Americans across this country, not only in Georgia, but from North Carolina to California, you may also visit www.ahrc.com. This website is the #1 property rights website in the world. We also have state websites, in particular for Georgia, www.georgia.ahrc.com. I thank you for your interest and your time, and I look forward to hearing from you. Don't hesitate both to rate the video and to give feedback. And again, I thank you for your time. May God bless and our property be safe for all Americans. For taking the time to get together to do exactly what the Founding Fathers intended, and that is to demand your rights and refuse to let anyone else take them from you. And that's really what life is. You know, somebody said to me, well, I can't write a brief, and I can't talk like you, and I can't do what you can do. And my answer is, well, bend over and kiss some part, whatever you feel comfortable with, goodbye. Yeah. Because that's what this country is, was, and will always be. Either you assert your own rights and you stand up and demand that government is what you want it to be, or give everything you have away and don't even bother. That's what your mama told you, or that's what my mother told me, and that's what the history of our country is. So while I may not be very tall, I do wear boots a lot. And I was taught to kick. And by that I mean to kick it in when it gets bad. I'm not one who believes in hurting other people. I don't believe in embarrassing my mother, myself, or my husband, or my children. But I do know what my rights are, and I've taken the time to learn them. And I thought that being from a family reared in this country since the 1700s, I had a pretty good handle on what being American was about. But until a British judge tried to take away my property rights, I realized I didn't know as much as I should. And the things that I was taught in public schools weren't all the things that I needed to know or to share with others. And so that's really how I came to be with you today. And while I'm going to tell you a quick little story that may cast me in a light I don't prefer, we are a legacy of experiences, whether as a country or as a human being. And the best that we can do, Jesus Christ tells us, is to share one with the other. And in that vein, we give back to God what He has given us, this country and our life and the very breath that we draw. So I'm going to talk real quickly about a legal situation, and I'm going to talk about how it affects everything you do, including the water that you drink. And I appreciate your patience. If I run too long, I know lots of signals. Don't hesitate to give me one, and I'll try to make it a little bit more comfortable. First of all, my name is Taffy Rice. My husband, Andy Rice, is here with me today. Andy is a retired lieutenant colonel and a captain of Delta Airlines. He worked through the Marine Corps for more than 20 years, and so we saw a good part of the country, mostly the South and the West. And we owned property, and we lived on government property. We understood when we drove on a government base that they could search us, they could seize anything we had, and we accepted that and he served the country as he thought he should, based on what he had been afforded and his family's commitment to the service. But when we settled in Atlanta, Georgia, a suburb, Cobb County, and we bought what we thought was every Southerner's dream, a brick home, a few columns on the front porch, didn't get much better than that. Finishing the basement ourselves, putting in the landscaping. Mom and Daddy helped me with the bushes, and I brought them back from North Carolina and dug the holes, and we set out to make a home and raise some children. We had no clue what God had in store. This neighborhood did not have covenants, as we had no regard for covenants or anybody telling us what to do with our property. Because if I'm making the payment, it seems to me I ought to be able to control that property. Amen. Now, just short of my husband or my mother, that's pretty much what we abide by. All that being said, this neighborhood did have covenants filed, but as we came to learn, they were filed improperly. And the way that the legal system currently views property and the issue of covenants or encumbrances is moving from a property law standpoint to a contractual law standpoint. Well, what does that mean? Well, property law says I sign up, whatever I buy, and I agree to it at the time I buy it, and you can't change it, no politician can change it, and no judge can change it. Whatever was written at the time you purchased your home, that's what you bought, that's what you signed up to, and that's what you've got. But what the courts are now trying to do is say, no, you actually engaged in a contract. You entered into an agreement, and as a result, we now have the rights to tell you what your property is going to look like, who will live there, what you will do in it, and how many pets and anything else that goes on. Now, some people may be comfortable with that somewhere, maybe, but I'm not. And that's not what I was taught my country was about. And that's not what statutory law says. But then we see Katherine Johnston. May God have mercy. A lady who obviously recognized that living in her home, she had the right to defend herself. And in the last legislative session, SB 396, known as the Taffy Doctrine, says you have the right when somebody walks in your home, if you feel threatened, to defend your property and your family. And that is codified statutory law. But yet, when Katherine Johnson, sitting in her home, received an invasion, more than 90 bullets were scattered about that woman's home, and she lost her life. Now, I don't know anyone that could justify that kind of brute force, and it is currently under the U.S. Marshal's jurisdiction, much like the Brian Nichols matter that changed the courthouse and the arming of our courthouses that also occurred here in Atlanta. Quite interesting. And I hope that you will follow that and learn more details, because what Channel 2 and the AJC and the Atlanta area want us to know about isn't always the full story as Paul Harvey might have wanted us to know. But specifically, let me say that in our story, when we received our invasion, that is to say, a law firm by the name of Brock Clay Calhoun decided that they wanted to impose covenants on our property. That's when we became more familiar with this transition that I spoke of from property law to contract law. And so it is in that vein that I want to speak to you. We purchased our home and had absolutely no covenants and restrictions. We specifically said to the seller, if it has them, we don't want the property. The deal is off. The closing attorney assured us there were no covenants and restrictions. The deed is unencumbered to this day and free and clear. We purchased our home in 1990. We closed in 1991. However, in 1996, we received a notice that said we have covenants. We filed them, and your dues have been zero, but we now like some money from you because you have a common area. So I went to Cobb County, to the deed records office, and I felt sure as the world there's 10 acres, and it is deeded to 76 owners in my neighborhood. Okay? The totality of the neighborhood is 113 people. But when the developers, in their infinite wisdom and governmental power, came into this land lot, they decided Phase 1 would be its own corporation, and Phase 2 and 3 would be its own corporation. So Phase 2 and 3 owners, 76 people, owned an interest in the 10 acres and 2 tennis courts. Phase 1, however, had no right or responsibility for that 10 acres. Okay? So what happens is, Phase 1, known as LMHA Inc., sent us a notice and says, we're going to sell your common area. Okay? We'd like to meet at the church to talk about it. So not only are they going to steal a property interest, not only do they not have the authority, whether it be contractual or in property law, to do so, but they're going to take me to God's house to do it. Okay? So as all the neighbors come in and we sit talking, my wonderful husband stands up like any God-fearing man and says, you can't do that. That's in violation of law. And 2 other fine men stand up and say, that's right. You don't own an interest. This can't happen. And there was a very short gentleman who was standing in the back, and he was moving on in years, and he said, we can do anything we can get a judge to say is all right. And we thought, you know, this man, he is older, I was taught to be respectful. You know, he may be suffering, he may not understand the law, you know. So we didn't challenge him until after the meeting in writing. And we said, you know, Georgia law says that you cannot provide an encumbrance on my property. You cannot assert as a corporation that you own anything that is in my possession, and you cannot take it. That's the beginning of our story. Let me suffice it to say it's been a 7-year odyssey. It has included county government, state government, the federal government, the governor himself, his chief counsel, and now the Georgia Supreme Court, before whom we provided an oral argument on November 7th, Election Day. Imagine standing before the Georgia Supreme Court and saying to them, the Cobb Court is being run not based on the rule of law, but based on fraud and racketeering, and therefore the citizens of Georgia cannot allow this to go further. Someone said as they watched the video, which is available on YouTube across the internet, that they saw one of the justices' eyes popping out when the word racketeering was heard throughout the chamber. Please understand, it has never been my goal to embarrass, to hurt, or to mischaracterize any person, whether they be a justice or anyone standing next to me. I wasn't taught that's appropriate. But the Almighty God sent His Son, and He said that we must give truth to one another. And literally, that is what we try to do in that courtroom. Now, as some of you have learned, truth in the courtroom is not a popular thing these days. And certainly don't mention your religious convictions. You won't find them well received. And you may even be incarcerated. But that is a choice that each of us makes. To the point of standing for your freedoms and absolutely telling truth, I will contend that to the day I meet my Maker, it is the path that's been set for me, and I will not stray. But each of us will make that choice. When we were faced with the law firm of Brock Clay Calhoun, you may or may not recognize some of those names. Mr. Glenn Brock is the senior partner. He brought Congressman Bob Barr to that law firm, who practiced with Glenn Brock, former Senator Charles Commander Chuck Clay, is the other partner, senior partner in the law firm of Brock Clay Calhoun. He is the former state senator for House District 37 in Cobb County and was our senator at the time. He is also the descendant of Henry Clay, the author of The Most Corrupt Bargain in History. He is also the former head of the Georgia Republican Party who handled the first Bush-Cheney campaign. And he is one of the financiers that brought Newt Gingrich to Cobb County. So as you might imagine, Chuck Clay has quite a far-reaching hand and arm that, as Ralph Epperson put in his book, extends the unseen hand to a degree that is almost unimaginable until you begin digging into the fraud and you learn the connections that are now being made along with the deals on your backside regarding your property. The law firm of Brock Clay Calhoun also has a third partner, Mr. Richard Calhoun, and he is the gentleman that chose to come after us. You might have heard of Mr. Calhoun. He's been in the news. He had a helicopter, his own personal helicopter, and he chose to fly it, much to his neighbor's chagrin, from his home in East Cobb, which did not allow helicopters to lift off out of their back property. However, while asserting he was the city attorney for Powder Springs, he allegedly was volunteering his flight time to look along the Silver Comet Trail, and therefore that gave him the right to have a helicopter out his back door and fly anytime he wanted, and to jeopardize his homes or the lives of his fellow neighbors. Now, let me tell you what's so wonderful about that story and the reason I've chosen to tell you these pieces. You know, 200 of Mr. Calhoun's neighbors didn't think that was too cool. They didn't like feeling helicopter rotors above their head. So they petitioned Cobb County. Now, Cobb County government, don't forget, is who Mr. Richard Calhoun used to attack my family. He's also a former county attorney, right? 200 people's voices were heard, and Mr. Richard Calhoun received a lawsuit for his helicopter. He had to remove it from the county, and he no longer has the right or privilege to fly that helicopter at the detriment of his neighbors. Praise God. So, while we may say, it's too hard, it's too big, we can't do it, you guys sitting here in this room together, the voices we have on the internet, the phone calls we can make, the faxes we can send, absolutely make a difference. And
Amen.
Amen. To give you a summation of our story, our car has been broken into in a TSA lot. Our house has been vandalized. We've been followed. We have been charged with crimes we did not commit, or properties we did not own. We have absolutely had our identities stolen. We have had his medical be questioned through a doctor who chose to provide information unrelated to his flight physical required by the airlines. We have had police files created on us that are noted in the billing records for the law firm. We have taken all of this information to the governor, Governor Sonny Perdue, who some of you may know, a former Democrat, now Republican. Kind of makes it hard to decide whether you like him or you don't, depending on, where you grew up or how you feel about politics. But without regard to how you feel, Governor Perdue was made known of absolute crimes, willful travesties. His oath of office does not allow him to condone. He held my youngest here with us today. He's sitting next to his father on his lap, and when we showed him the documents and we explained what was happening, he said, "This can't happen in Georgia." And he turned around and sent me to his senior legal counsel, Harold Melton. Harold Melton is now Justice Melton, who I spoke before on November 7th. And while the Supreme Court was such an awestruck experience, imagine, I said to my children, Mr. Wiggins, who chooses to unseat Justice Hunstein on the Georgia Supreme Court, has never argued before the Supreme Court, the body to which he would now like to be a member. And then there was Perry McGuire, who wanted to unseat Thurber Baker as the AG for Georgia, the most senior legal mind in Georgia. And he had never argued before the Georgia Supreme Court. So I said to my children, God has given us an experience, and you must soak in everything that you see and that you hear this day. in order to understand what our country was founded on and meant to be. So as we entered, we expected it to be rather awe-inspiring and intimidating, as most people do in court, but it was awesome. These people were actually having a candid conversation with the presenter, asking them specifics and seemingly wanting to get to the heart of the matter. And I was awestruck. I couldn't believe how wonderful it was that we were going to be able to talk about property rights in Georgia before this body. Unfortunately, however, two things occurred. One was I got asked only one question, and the other was they refused to allow a rebuttal. And by the way, I was arguing against the Georgia Attorney General. When Justice Melton asked me one question, he didn't ask me, was it a dissolved corporation that had no right to do business? He didn't ask me, was it covenants listed with your deed? He didn't ask me, did Judge Grubbs discuss the case prior to walking into the courtroom? He didn't ask me, did Judge Grubbs derive benefits when she falsely ruled against you and against Georgia law and subsequently every citizen of Georgia? Instead, he said, Mrs. Rice, now I haven't had a personal discussion with you about this case, have I? So lost was the concern for the legal issue or the property rights of every Georgian. The concern was, wait a minute, am I involved here? Which much let me down, I have to say. I tried to politely explain to Justice Melton that, well, you did receive 327 pages of evidence, which your assistant told me you had reviewed, and you viewed as a separation of powers issue, as I remember it. There were no other questions, not of me. There was only one other justice who asked a question of the AG. And with that, let me back up and just say that, one, again, we were sued by a dissolved corporation, LMHAE, which cannot happen. A dissolved corporation has no standing to bring an action, much less to sustain it. It is a nullity, and referred to as legal necromancy, as I investigated and paid lawyers to explain to me. And then the second corporation, when we made this point, we prevailed on it, by the way. They added a second two-part plaintiff. They added the ACC, Architectural Control Committee, of another corporation, LMTHA. Not LMHA, Phase 1, not LMTA, Phase 2 and 3, but as though there was someone who had a lisp, and they came up with LMTHA, okay? And we said LMTHA, we went to the Secretary of State's website, and we found LMTHA didn't exist. Then we began looking at the covenants that they purported for LMTA. So let's see, they're suing me as LMHA, but they're using the covenants for LMTA. Okay. When we looked at the covenants for LMTA, they said only an architectural control committee could sue, not a corporation. Okay. So what did it take to make an ACC, whatever that is? And we found this fine little paragraph that said ACC. And it's a body or a group that's formed, and a document is filed with the county to let everyone know that you have an ACC. So we went to the courthouse and we looked. There was no ACC. So see, I'm sued by a dissolved corporation and two entities that don't exist. Now that makes me feel good about the rule of law. So what we decided to do, being graduates, our college, and got to count for something, right? We didn't work 3 jobs for nothing. We decided that we'd form the ACC and we'd form the corporation. That's not too hard. Anybody can do that. So we formed the corporation LMTHA, of which my fine husband is the CEO and I, his CFO, always trying to protect that bank account, And lo and behold, I contacted the developer, now escaped from Georgia, doesn't want anyone to know his name or his address, of course, and he just happened to be Rankin Smith's son-in-law. He was very kind to help me form an ACC, and he asked me to go to his attorney, which I did, and she drew up the ACC of LMTHA, of which I and 3 others are the sole members, and the requisite, you might ask, what did it take to be on the ACC? You swear you're not going to take advantage of anybody? You swear you're not going to sue? You swear you're not going to hurt your neighbor? You're in. That's what our ACC was made up of. Decent people who would not turn their back
before Judge Grubbs on March, and we had our lawyers, and 4 lawyers. We absolutely thought this is a slam dunk, we're golden. We've done God the best that we could with what we had. And Judge Grubbs said, a dissolved corporation? I don't want to hear any more of that.
Hallelujah.
Then we said, we are the ACC. We are LNTHA. What witnesses would you like to call? She said. So when I got on the stand and I explained that we had erected a fence, not a fence because we wanted one, 8 years of living there hadn't motivated us to erect a fence, but because we were being videotaped in our backyard, because our house had been vandalized, because our contractors were threatened when they came to our home, because the county was sent to our home 17 times, and my children could not walk in the backyard for fear, and were afraid, becoming increasingly afraid to sleep in their own beds. That's why we built a fence. She told me that I could not testify to that she would prefer I didn't mention that in court, and she was sure I wouldn't understand, but it would be best if I did. Now, I had already said these words, so I wasn't too concerned, but it did seem rather strange. Nothing so strange as the verdict. The verdict was in favor of LMHA and the ACC of LNTHA. So my husband and I immediately asserted our rights as the officers of LNTHA, and my neighbors and I asserted our rights as the ACC, to which Richard Calhoun created a second ACC, which she ruled in behalf of theirs. Not the first duly recorded, but the new one he'd created on paper with falsified documents. When we asserted our rights as a corporation, Judge Grubbs told us if we did that, or we continued to speak of it, she would immediately incarcerate us. So we began to work on our appeal. We had 13 enumerations of error. Only 7 would fit in the page limit we were allowed. And we thought, this can't stand. It was particularly brazen when Attorney Richard Calhoun, when filing his response to our appeal, changed the name of the plaintiff appeal. He no longer wanted to be just LMHA and the ACC of LNTHA. He now wanted to be LNTA, he had decided. Unfortunately, the ruling for Judge Grubbs was final in the Superior Court, and therefore the appeals court rules do not allow you to change the name on appeal. However, when we filed our motion to strike and overturn for violation of rules of the court, opposition to statutory law, and direct obliteration of constitutional law, the unimaginable happened. Who would think that an appeals court judge not only would not admonish a lawyer so clearly breaking the law, but he changed the name of the prevailing plaintiff to yet another entity never even asserted by Calhoun. We were prevailed upon by LMHA and the ACC of LMHA. Now, while all of this sounds unimaginable, let me just tell you the Supreme Court would not even review it, okay? So you're scratching your head saying, God, I just lost, and yet I did everything I could. And then there was the issue of the judge. So we went back, and when we were told by District Attorney Pat Head, some of you might have heard of, that Judge Grubbs was discussing our case before the Chamber of Commerce prior to hearing our case, we went, oh yeah? So we subsequently filed a writ of prohibition. A writ of prohibition is a document that prohibits a judge from acting when they have violated the law. And that, ladies and gentlemen, is what we argued before the Georgia Supreme Court, the writ of prohibition against Judge Adele Grubbs. Because a judge cannot act in a biased fashion according to the laws of this country. A judge cannot have a money interest in the outcome of a situation before they hear it. And clearly she did. And therefore every act she took after was void as a matter of law. That is what is currently pending before the Georgia Supreme Court. And if it were to prevail, then everything that happened would be undone. I'm going to quickly close and wrap up and just tell you what the importance of this is to all of you. If the case precedent, that is to say when Judge Grubbs took us in her back room, if you will, courtroom D, and she decided to violate the law against my family and every Georgia property owner, and subsequently applied to every American property owner, she gave lawyers the right to turn property law interest into contract law. She gave the right to a dissolved corporation to sue you, even though you have no contractual relationship with them. She gave the right to threaten you if you assert your corporate rights. Now, I'm going to tell you that we received 7 lawsuits resulting from this. And if you can imagine a husband and a wife trying to survive with 3 small children with 7 lawsuits, and every lawyer doesn't want to lose their bar number, and the super lawyer of the United States told me, I don't practice that kind of law. Then let me just explain to you that when you walk into a courtroom, there are very few lawyers who are working for your interest. When a lawyer completes their legal training, they become members of the Bar Association for the most part. If a lawyer steps out of line, as I went to court for another family, when the lawyer asserted the violations of law, he was threatened that his bar number would be removed by the judge if he continued to argue. You got to understand, that lawyer works for the courts. That's where he's making money. He secondly has an allegiance to the ends of the court or the Bar Association from which his license was derived. And then whatever money you can pay him is about as much of his attention as you're going to get. But you, ladies and gentlemen, have a right. And just as LT said, you need to learn how to present yourself. But more importantly, the culmination of our story, which I'll be glad to share and help you in any way, learn more about the avenues, is it doesn't matter what you say in a courtroom. It doesn't matter what you look like. It doesn't matter what money you have. The way this country was founded, and the only rights you will ever get is if your voice are heard. And if voices are collectively heard, that's the only chance you have to obtain justice in this country, and that's a fact. What I personally did was I joined a group, AHRC, which Larry spoke to you about. This is an organization that's been in business for 15 years. It is free of service. It is totally committed to the property rights of Americans. They'll not ask you for 1 penny. You can write whatever you choose. You can post whatever you like. But it is your voice on the internet that cannot be squelched. Let me tell you 2 things. On AHRC, we not only have a global website and a presence, but we are the #1 property website in the world. We are picked up by Google. If you would search on some of the folks, some of the, as my kids like to say, bad guys, on the internet, you will find when you search on their names that you get my articles. Okay? That's how in tune the search engines and the people who control the rankings are on property rights issues, because they are not being covered by the major media. Every media source in this country is owned by 9 corporations. Do you think your interest against them is going to see the light of day? It's not going to happen. But with AHRC, you truly have a public voice. Not only are you able to write your own article, and don't worry about your spelling, don't worry about anything but getting the facts out there and your voice heard. But in addition, if you're sued, if you know an organization you've dealt with, say the ACLU, who hasn't picked up an issue for some reason, because they are very selective, I might add, you can file that lawsuit, that is to say, load that lawsuit to the internet. Okay? Every pleading you do can be posted on the internet. People can make comments to your stories. They can forward them to news media. You can fax those documents. And all it takes is hitting the website www.ahrc.com. You can log in, create your own user ID, you can create your own blog, you can create your own email, and get your voice heard. In addition to AHRC, I want to tell you that for every state in the union, we also have state websites specific to what's going on in that area. I am the editor for Georgia AHRC, and anything that you submit, as long as you don't curse, you're not offensive, you can have your voice heard. But more importantly, on the AHRC website, the last thing I want to make you aware of is you can attach documents. Let's say you had an order from a judge and it makes no sense. Ever had that happen? Let me see. Just got one. It happens that the judge, Judge Adele Grubbs, wrote a footnote and a personal message to me in a case that I'm not a party. Why would she do that? Well, let's see. I wrote an article about a woman wrongly incarcerated for 18 months in violation of law. Just happened to be Judge Grubbs. just happened that Judge Grubbs had engaged in ex parte communication with the ex-husband lawyer. Just so happened that she incarcerated her for a debt she could not pay in violation of Georgia law and constitutional protections. And it just so happens that Judge Grubbs was made aware in the courtroom that the woman was under federal bankruptcy protection. Quite a few problems there, really, when you think about it. So what happened was I got subpoenaed to the courtroom in a case I was not a party to. Wonder why. But the best news of all is that for the first time, Marla Alien Wright prevailed on the plea. And Judge Grubbs recognized, we're watching. So the footnote message I got, well, you know, that's all part of reporting, and I want you to keep that in mind. But for the Chuck Clays of the world who control the Wellstar Network, the hospitals, the power company, the Senate, the politicians, you know, having a voice really makes all the difference in the world. And it truly is the only thing that's going to give your court system a conscience. So I thank you for your time. I've got one other website, www.ricegang.com. That's our personal website. You'll see the scanned documents, have a better feel for exactly what happened and some information. And the only other website, we did run, one thing I left out, didn't want to talk too much about us personally, but my husband and I decided that we would run for political office. You know, if the politics and the law were beating us, I took a legal course and we ran for office. And we went to the U.S. Attorney, and we went to the Georgia AG, and we said, excuse me, we're now candidates. We have different rights. We want political corruption and judicial misconduct investigated. And within 24 hours, Judge Grubbs ordered our arrest. So let me just tell you, it does make a difference, and you'll learn more about that on the website, www.electrights.org, the first couple to ever run in tandem in the history of this country. You've probably never heard of that. You'll find more information about it there. But I would encourage you, more importantly, to get HRC, learn more about your property rights, and make your voice heard.